Good morning. Welcome. Today is Tuesday, September 23rd. Welcome to the First District Court of Appeals. So this morning we have a few matters on the docket. We only have one case that is scheduled to argue. All right. Now that I have my good eyes, we have three cases on the docket. The first case has submitted on its briefs, will not be arguing this morning. It's case number C240723, State of Ohio versus Clarence Higgins. The second case is scheduled to argue, and if the attorneys can identify themselves in their readiness to proceed, let me call it first. Case number C250059, State of Ohio versus NS.
Morning, Your Honor. Sarah Nelson on behalf of NS, ready to proceed.
Good morning, Attorney Nelson. How are you?
Good, how are you?
Are you enjoying the rain? Everyone's commenting on the rain this morning. Yeah, you could tell it's been a while, right? We're all like dehydrated somehow.
Your Honor, my name is Sean Webb, I'm the City Safety Manager, filling in for Joseph Cousin. It's new to the office. Joe Cousin was on parental leave. He had a child the last few weeks.
No worries. Well, we're glad you're here. Thank you for filling in and welcome. I understand there's some paperwork that will be completed after the argument.
That's correct.
It's not an issue, okay? All right, and then the third case we have that's scheduled to argue is case number C250038, Curo and Diath versus Racine and Diath, and that again has submitted and will not be arguing. Attorney Nelson, whenever you're ready.
Good morning again.
Good morning.
May it please the court. Good morning, opposing counsel. I'd like to reserve 5 minutes for rebuttal, please.
Okay, perfect.
Thank you. This case concerns the record sealing and expungement laws. My client, NS, applied for both record sealing and expungement, but the trial court in this case only granted her application for record sealing. So this appeal is based on the denial of the application for expungement.
Can I ask you real quick, because I got very confused. The trial court in the order says this is an application for sealing and expungement
Yeah, it says.
at the beginning of the order, and then at the end of the order just grants the sealing but doesn't talk about the expungement.
That's correct.
Could this have just been an oversight? I mean, how do we know that this was denied? I mean, are we just assuming denial?
We're assuming denial.
Just assuming denial?
Yes, based on the language at the end that says granting sealing with no reference to expungement, I read that as only granting the application for sealing because there were two applications in this case. They should be given.
So because he just didn't mention the expungement in his order, whether it was an oversight or not, we just take it as a denial?
Yes.
Okay.
That's how I interpret the record because it's not clear.
Okay.
So,
Is that an issue that both were heard at the same hearing? That the application for expungement and sealing were both heard together?
yes, I believe they were set together.
Yeah, but is that an issue?
Oh, that they are set together?
Yeah.
Uh,
Because the form only says check one.
Correct, which is why we filed two. So,
Okay. So they can both be heard at the same hearing?
yes, there was no objection to having them both heard at the same hearing, and as a matter of practice in Hamilton County, that's how it typically goes. If they're set on the same day, they're heard at the same time, they're basically filed both as a matter of practice, just in case we file on something that's not eligible for expungement, because there are some misdemeanors that can only get sealing treatment. I know NS came through the Hamilton County Fresh Start Clinic, so speaking from that experience, that's why we file for both, just in case. But this is a rare situation where the application for expungement was denied. Whether or not it was oversight or intentional, our basis on appeal this morning was why that was error is because the factors for sealing and expungement are exactly the same. And when the trial court goes through.
The factors are the same, but there's a different outcome, right?
The relief is different, yes.
And so under one, there's going to be some limited access. Under the other, there's no access whatsoever.
Yeah, permanently irretrievable or just shield from the public,
Okay.
yeah.
So it seems to me what you're saying is the considerations are the same, but because there is some access, I'm trying to figure out, is really the considerations the same in determining whether the court determines whether it's more proper for there to be absolutely no access or for there to be some access. So while the factor's the same, but the considerations in weighing things, are they really the same?
The statutory factors that the trial court has to consider before granting either application are exactly the same. There is no ambiguity there.
Correct. You got me there. Yes,
If
I'm
the
all
trial
in.
court, I'm not here to suggest that the trial court could never grant sealing and deny expungement. There are certainly circumstances where a trial court might find that appropriate based on the remedy that you're alluding to, permanently irretrievable, something along those lines not being appropriate. But there was no argument to that effect in this case. None whatsoever. No party raised that to the court's attention, seeking one over the other, and the trial courts.
Were there arguments against?
There were generic arguments by the city. They objected to the applications in this case. Their written objection cites both sealing and expungement. Because those words unfortunately have been interchangeable for so long and up until recently got actual separate treatment. So whether or not that was an oversight or they intentionally wanted to object to expungement, I think it's a bit ambiguous. But the arguments that were raised in their objection, the trial court addressed in its entry for overruling them in the name of sealing and made no indication that they were appropriate with respect to expungement. So I don't think that there was any expungement-specific argument raised in this case. Not to say that there could never be one, but there wasn't in this case.
And so are you saying that there has to be an expungement-specific argument?
I think if the court wants to grant one over the other, there needs to be a specific argument as to why. Because the statutory factors are exactly the same. There's no reason under the statute to provide relief for one over the other, just based on the factors under 53.32D. And in fact, under D2, where it talks about what the trial court is supposed to do after the statutory factors are considered and found in the applicant's favor, it does address both. If the application is for sealing, the court shall order the record to be sealed, or if the application is for expungement, the court shall order the application or the record expunged. And they're both in the same subsection, D2. So there's some language indicating if you file for this, they get the same treatment, you should be afforded the remedy that you sought.
So are you saying that as a general rule, once the trial court determines to seal, if both are filed contemporaneously or heard contemporaneously, once a court decides to grant the motion to seal, that necessarily then the motion to expunge should be granted?
Yes.
Considering the different functions of the expungement versus sealing, could a trial court determine that one of the statutory factors is not met with expungement versus sealing? Does that make any sense?
Yes, it does. I'm sure the trial court could. I'm sure they could.
Okay.
I mean, there's nothing in the rule that would preclude that.
So because of the nature of the relief, the trial court could say, we got all the findings for sealing, but under expungement, because of the nature of the relief, we don't find certain other factors are met.
If the trial court said the nature of the relief is the reason why I'm denying the application for expungement, respectfully, I would litigate something like that on appeal because I would want to know what this court had to say about that. But I'm sure a trial court, if they had specific reasons or a specific instance why, for example, it's 0.33 or 0.34, I believe, there is a subsection that talks about the entities who have access to a record that has only been sealed. So I can imagine a scenario where, based on one of those specific factors, where an entity can peek behind the curtain of a sealed case, perhaps in that scenario, if a party is offering that, if a court is citing one of those factors, that there could be a scenario that would lawfully, or not an abuse of discretion, suggest that sealing is appropriate in this case, but not expungement for these specific reasons. But those are statutorily identified, so it can't be just anything. It has to, I think, be within what the legislature has narrowed in terms of access to these records.
And that's the fundamental problem here, because we don't know, because the trial court was silent as to the reasons for not granting the expungement.
Right, which could easily be oversight, or if it was an intentional denial, then I think that that's an abuse of discretion because all the statutory factors were found in her favor. There was no specific argument as to expungement, and the statute says shall order this upon an application for expungement.
I'm looking at the state's objection, and it's entitled State's Objection to Applicant's Motion for Expungement.
Yes.
Okay.
And
And then in there, I know what you,
throughout, it's just interchangeable.
well, yeah, but it does make, this statement, the government maintains an interest in allowing the public and law enforcement to know about applicant's criminal conviction for theft and menacing.
And
So are you saying that that only goes towards sealing and cannot go towards expungement as well?
I suppose it could, but in this case, the trial court did not find that argument persuasive. I think it found it to be too generic and didn't give it any credence. And also to that point, the law enforcement access to records is something that law enforcement is always going to have, especially in the context of expungement. If somebody is ever going to apply for a law enforcement position, law enforcement's going to have access to those records. So this generic need for law enforcement to have
Okay.
access to these records, I think the trial court found to be unpersuasive. But in the context of expungement specifically, I don't think it's an actual concern, because if they're
Well,
going
the
to
argument
apply
is
for law
public
enforcement
and law
positions.
enforcement, so I hear what, so,
Yeah, and there are, I believe it is 0.34, other entities that have access to records despite a sealing and expungement order. So,
Okay.
when it comes to the types of relief, the legislature has accounted for circumstances where people are still going to have access to these records. So when we're dealing with the trial court's decision, if the factors under 2953.32D all fall in the defendant's favor, both applications, if presented, should be granted, absent extraordinary circumstances under the statute.
and Attorney Nelson, do you know, was there restitution in this case that was ordered? In the underlying case, in the underlying cases?
I don't believe so. I don't recall that as a basis for objection. I don't recall that. I'm not sure, but it
It's
wasn't
okay.
a topic
It's
at the
okay.
hearing. Typically it is, though. Typically, if there's outstanding restitution, someone's making an objection on it. So I would submit that there probably wasn't. If there are no further questions, I'll reserve the remainder of my time.
All right,
Thank you.
thank you. Good morning, Attorney Witt, how are you again?
I'm doing well. Good morning, Your Honors. My name is Sean Wedd. I'm representing the City of Cincinnati appellee on this issue. And the issue before the court is whether it was an abuse of discretion for the trial court to grant the sealing and deny the expungement in this case. The abuse of discretion is governed by whether the trial court's decision was arbitrary, unreasonable, or unconscionable. And I don't think the fact what is in the record rises to this level.
We can't even tell if it was an oversight or he purposely denied the expungement. I mean, isn't that kind of a problem in and of itself?
So the statute under 2953.32 requires the trial court to go through all the factors. He did a written entry, and then 6 days later, after this fact, didn't put in the record that the application for expungement was denied. While he didn't address that specifically in his written entry, it was eventually in the record. So it was clear that he decided to deny the expungement.
So
the
on the
factors are-
judgment sheet or something, he just wrote that down on a judgment sheet?
Yes, that was 6 days after the fact, I believe, on January 23rd.
Application denied. It doesn't say for expungement.
Based on the record, we believe that since the granting for sealing took place, that was the only thing that
Okay.
could be denied at that point.
And that's when, I mean, I was looking at what was filed, and it's a bit confusing to me, because there's a box checked here that says application to seal a record of non-conviction. And that's on the 12607 AB case. Let me see, did I print this out twice? 21. Because both of them were talking about non-conviction, and there's only one non-conviction here.
Yes, I believe that was likely an error of the application. There was a plea here, and I believe that the menacing was dismissed per plea, and the
Right.
theft was a conviction in this case, and they were trying to seal and expunge both the dismissal per plea and the actual conviction in this case.
I think that's, but the filing was only referencing a non-conviction, and there's only one non-conviction here.
I do think it was a little ambiguous when the application was filed, what exactly they were seeking. I know this is the Fresh Start Clinic, and it may have been error on their part. However, I think at the actual proceeding, this was a relatively thorough process. There was an application, objection filed from the state, an initial hearing, and then a secondary hearing where the prosecuting witness was present. And it was clear to the trial court, who was in the best position to either grant the sealing or grant the expungement, and he knew all the factors. He even set it out for a written decision, going for the 2953.32D, and that's where he determined to grant the sealing. I think the trial court was in the best position to review it, and it was the trial court was informed of the decision. He determined whether the defendant was rehabilitated. However, I think he made the distinction of granting the sealing rather than the expungement, because as Your Honors mentioned, they are different things. The sealing.
But we don't know that. That's all guesswork, right?
It is not clear in the record why he chose to do sealing and
But
expungement.
the factors that are to be considered are the same for sealing and expungement.
Yes.
And
yeah,
the court
factors
found
is-
that those factors existed for sealing,
Yes.
correct?
The court did.
And so
find-
how is it that if those factors existed for one, they could not exist for the other?
Well, I think, Your Honor, the threshold for each is likely higher, as it is in the discretion of the trial courts, as the sealing is just to hide the criminal record from the public gaze. An expungement is making the record permanently irretrievable. I think that given there are different things with different repercussions, that it is within the trial court's ability to make that distinction, that one is appropriate as opposed to the other.
And that needs to be explained.
And if this court does determine that the trial court, when they have both dual applications in front of them for sealing and expungement, and grants only sealing and not the other, I think under State v. David, one of the cases we cited in the city's brief, the remedy in that case was sending it back to the trial court to making their thoughts clear of why they granted one or the other.
Is that what we should, are you saying that's what we should do here?
The state's position is that the trial court did evaluate all necessary factors, and I think he knew what both applications were in front of him, as in the 6 days later, that he did say that the application was denied, whether he meant expungement,
Okay.
that's the state's position.
Yeah.
But if that is what the court determines, I do think that is the proper remedy here. To send it back to the
Because
trial
we
court.
can't really, I mean, this is an abuse of discretion.
Mhm.
And I don't know how we can make a determination of whether he abuses discretion in granting one but not the other if we don't know why he didn't grant the other.
Yes, I do think while he did go through all the factors he needed to, as they are identical, I think there was no clear reason why he did not he granted one and not the other.
Right.
And again, while I think the trial court was in the best position to review that, make the decision, if it is determined that the trial courts must do that, the dual applications, I think going back to him may be the best decision, if your honors find that appropriate.
Are the state's interests the same for an application to seal and an application to expunge?
Your honors, I would argue no, that is not the case. As your honors, I'm sure you're aware, there were some criminal cases were only available for sealing and non-expungement, and then there's a reason for that, as they're enhanceable. There's like while I know they are available, even expungements are available to law enforcement in certain situations, they are harder to retrieve, though, generally when checking criminal records in the courtroom. And I do think that because the distinction exists, there is probably a different analysis that trial courts would need to do, despite the factors being the same. I think there's plenty of cases where trial courts can determine that sealing is the appropriate remedy, that there is proper rehabilitation, but that law enforcement should at least keep the record intact so it's retrievable in some aspect.
In the bench, considering the factors,
Mm-hmm.
which are, it's the same factors, right?
Yes.
How would they play out differently for the bench in a sealing versus expungement?
So the factors that exist are set up by the legislature, in my view, is a roadmap that the trial courts must do. And that is just to kind of compel the trial court to properly evaluate whether the sealing or expungement is necessary. It just requires them to go through all the factors, rehabilitation, interests of the state, what is the purpose for the defendant seeking this. And I think while those factors are identical for sealing and expungement, I think it could still be different for the trial court, given that the remedy and end result are so different.
In this case, what was the stated purpose for the reason?
Yes, so in this case, the state's initial objection was going to the seriousness of the offense and just saying that being available for law enforcement and other purposes. I think the trial court heard from the state and the prosecuting witness was present, and the defendant stated her reason for wanting this in the transcript, and her reason was going for education, promotion for a job, and that's things that sealing is beneficial to, because those aren't easily accessible for the background checks. But for law enforcement purposes, the record's still intact. It's easily defined for law enforcement, but not for the public, it's hidden from the public gaze in that aspect. And that's what I would argue that the trial court, that was the reasoning for granting the sealing and not the expungement. And I still think that the state's argument of why to preserve this is kind of identical for the expungement argument, so the record is retrievable, because the expungement basically just destroys it, and it's harder to find.
So is it your position that we shouldn't be presuming the regularities, that we should be remanding it?
The state's position is that we find that the trial court did the things it needed to do. It did a thorough process, a thorough analysis, but in the alternative, if this court determines that the reasoning is not clear, for the trial court, it should go back to the trial judge to just make his reasonings clear, why he thought sealing was appropriate over expungement.
I thought you agreed that he didn't make clear his reasoning for the expungement denial.
So he did not, in his written entry, he did not make
Okay.
it clear. Yeah, I think his intent to deny the expungement was in the record. I will say his reasoning for doing so, it does not.
Okay.
And that's where my presume the regularities question comes from. Because, as you know, as a matter of law for many criminal cases and even civil cases, the trial court need not articulate everything if it's presented.
Yes, and that's.
And I think what Attorney Nelson is arguing is that it wasn't presented.
When the trial court made its decision, the 2953.3 statute is identical for sealing or expungement. And if this trial court had just did articulate one extra sentence, why it added in its entry, why it determined sealing was more appropriate than expungement, that would be all that's necessary. Because the trial court did evaluate every factor it needed to. It just did not articulate why it chose to do sealing as opposed to expungement. All other factors that are necessary in this case were met. He did kind of hear from both sides, determine rehabilitation, and he did in the end find the sealing was appropriate despite the state's objection.
So is this a situation where the trial court would do one or the other to any given case?
I think the trial court has the discretion to make that the case, that they can do sealing or expungement when there's dual applications if heard at the same time. I don't think that they are compelled that if a sealing is granted, that they shall have to
Right.
complete
But
the
what I was
expungement.
asking is it that when they're both filed, so I think we've established that they get filed separately, okay? And that's also my reading of the statute. And this is what happened here, but they were filed contemporaneously, heard at the same time. So is the matter before the court to determine one versus the other, or can the court determine both?
I think the matter is to determine kind of one versus the other, because it's clear that the sealing, and I don't think it's argued by defendant appellate that the sealing was done inappropriately. And it's not argued by the city the sealing was inappropriate because all factors were considered. It was just the only issue here, I think, is whether the expungement denial was proper, given he did not make the distinguishment.
Because
in
it
its
raises an
reasoning.
interesting question on remand.
Mhm.
So if the trial court was to say, oh, yeah, I messed up, it should be granted, then shouldn't the sealing be vacated?
And I think that is a full possibility if it's remanded to the trial court, but I do think it's just the expungement at the end of the day. The sealing, I think, is complete. It's just whether, if it goes back to the trial court and it truly was an oversight, I think he may choose to grant the expungement. More simply, he would just explain his reasonings for denying the expungement if given the opportunity.
Mhm.
I think we're just going back to the abuse of discretion
You
argument.
still have a couple minutes.
Yeah.
Okay.
Going to the abuse of discretion, mentioned state, so in one of the state's cases cited in our brief, Lang Zhong Yu, in that case, there was no clear reason why the trial court had denied the sealing or expungement. And that was considered an abuse of discretion at the first district. And the argument here that the state is going to make is that the reasonings were considered, the factors were considered, that all the factors are identical, and that they were articulated by the trial court, and that it went through that analysis. And that was an example of abuse of discretion. Because the whole purpose of the statute is to provide the roadmap to the trial court so they properly analyze all these factors. And when the trial court has done this, I think it is in the purview and the discretion of the trial court to either
The case
grant
that you're
or deny.
citing, what was the issue in that case?
In that case, it was just it was a sealing or expungement, and the trial court had simply not articulated its reasoning. The hearing was vacated, and they just denied it in absence of a hearing. So it did not give the defendant any opportunity to present its reasonings for seeking the sealing or expungement, and it just denied it.
So that
outright.
had more of a procedural issue.
Yes, and I think that was an example when the trial court's decision was arbitrary, as they didn't go for the roadmap. And there's a case I mentioned earlier, State v. David, was another case where it was sealing or expungement. That was a case where the judge, in the middle of the hearing, when someone was seeking a sealing or expungement, they cut off the defendant and just ended the proceeding saying, I'm denying the sealing, not allowing and going for the steps of going for the factors of 2953.3.
So those were both more it sounds like due process issues.
I think it just goes to the fact that the purpose of the statute is to analyze the factors and determine whether defendant is rehabilitated in the interest of state. And I think that's when the abuse of discretion comes in. The trial court here did go for all the factors. It did consider everything that it needed to make the determination. The only issue here is whether it stated its reasonings for doing one over the other.
And it did not.
Yes.
And you're okay with us sending it back for the trial court to straighten that out?
Your Honor, if that's the position of this court, while I would think the trial court did go for the factors it needed to, but I think that is the proper remedy if it's determined that was not the case here. If it was an abuse of discretion and it did not articulate its reasoning, the trial court, it should go back to the trial court to determine why he did one over the other, state the reasonings, or maybe if it was truly an oversight, maybe he grants the expungement.
And the granting of the expungement makes the sealing moot.
Yes, this, then basically the expungement's the higher level almost, I would say, as it's permanently irretrievable as opposed to just shielding from the public gaze. Let's see. Your Honors, if you have any more questions for me, otherwise I'll yield the rest of my time. Okay. Thank you, Your Honors.
Thank you.
So Attorney Nelson, you had a minute left over, so you have 6 now.
Okay. I think we can move forward comfortably with the fact that this expungement application was affirmatively denied based on the principle that motions not explicitly considered are effectively overruled. So I know
Well,
that
it looks like it's in the judgment.
the judgment
Judge's
entry on
sheet.
January, I think 17th, said application denied.
Yeah. Well,
And
the
when we
the
appealed-
sealing was granted.
When we appealed from that, we thought that that was both sealing and expungement until February when we got a letter from the client fact where she received her entry that was omitted from the record for whatever reason. So I think that's why I came with it was a little ambiguous because of how it played out, but effectively it was denied.
Okay.
So I agree with that.
Yeah, that makes sense.
Okay.
And would you also be good with us sending it back for the trial court to explain its reasoning for denying the expungement?
No, I don't think that that's the appropriate remedy. I think
Okay.
that this court should remand in order that the expungement be granted because the trial court did go through the statutory factors in this case. This is different than that the state just referred to where the remand was for complying with the statute to go through the statutory factors, which they did not do when they denied the application.
But I
Trial
thought,
court-
you said that because of the different nature of the relief, that the trial court could conclude differently with respect to factors when evaluated for expungement versus evaluated for sealing.
With respect to the factors that they have to consider, there's no difference between sealing and expungement. My argument earlier was that the trial court could conceivably come up with a reason separate from the D1 factors that would warrant maybe possibly denying the expungement application. But no argument to that effect was made in this case, and there was no indication that the trial court was even on that path because it went through the D1 factors in this case.
So the D1 factors are not impacted by the nature of the relief?
Correct.
Okay.
Correct. So I think on this record, this is a unique situation where we have the statutory factors, the court complied with them, went through all of them. There's just no indication, no argument, no reason to depart from expungement when they're met. And the statute says if an application for expungement is before the court, it shall be granted if the factors are met.
I'm trying to wrap my mind around your argument that there was no arguments made to differentiate between sealing and expungement. And it goes back to that statement that's in the state's opposition memorandum. The government maintains an interest in allowing the public and law enforcement to know about the applicant's criminal conviction for theft and menacing. So because the public interest access would be, would then be denied pursuant to an expungement, would be, right? I'm trying to understand that you're saying that there's no argument raised, and it seems to me that this would be an argument.
I interpret the state's argument as going to both sealing and expungement. It gets wrapped up as one,
Right, but
not
the
separate.
interests are different in the two, because one is shielding as a whole, and I
Right.
know that there's some carved-out exceptions, right? And the other one is shielding, but not as a whole.
I'm sorry, can you repeat the
statement?
yes,
Okay,
in the
sure.
state's, yeah.
The government maintains an interest in allowing the public and law enforcement to know about the applicant's criminal conviction for theft and menacing.
Okay, so to that specific statement, I have two responses. One, this court has already said that the general public's right to know isn't a sufficient circumstance to deny sealing and expungement because the legislature has already determined that these types of offenses are eligible for this type of relief. The state has not cited any sort of extraordinary reason why this case should defy the statutory mandate, which is allowing these to be eligible. They have no specific set of circumstances, and this court has already said that that's not a sufficient interest. And the trial court in this case also found that that interest was not sufficient in granting the record sealing application. So when I say that there was no specific expungement argument, the state is not making any specific arguments as to why it should be not rendered permanently irretrievable, because the public's never going to know of the record even when it's sealed. So their interest in maintaining the record, that goes to sealing. That can't go to expungement. And with respect to law enforcement, as I previously stated, their interest is in employment. And my client at no point in this hearing said that she was interested in seeking law enforcement positions. She's was pursuing a social work degree. I believe it was working at Talbot House, was up for a promotion. That is completely separate from the types of entities that the statute would allow for possibly peeking behind the curtain or maintaining the record for law enforcement purposes in the name of expungement. So the state-specific reasoning, again, is not expungement-specific to me. It's not consistent with this court's precedent regarding the public's right to know of certain types of convictions. That's also inconsistent with the legislative mandates that these are eligible. So I don't interpret that whatsoever.
Understood.
as-
Thank you so much for
Yes.
answering my
I'm
question.
trying to understand why you disagree with us sending this back, because I'm looking at that, is it Lan Zheng's Yu case, where there was no analysis done, and that was remanded back for an analysis to be done.
There was no analysis whatsoever across the board in that case, which I think is distinguishable where we have an analysis under the
But we only have
D1.
an analysis with regard to ceiling.
We only have an answer with regard to ceiling. So if this court wants to send it back, then I would caution this court to not let the trial court do the expungement hearing anew, because the factors were already decided. This issue should be decided on this record, and effectively expungement should be granted because the statutory factors and all the arguments before shouldn't change.
I don't think that that would be a remand to redo an expungement hearing. I think that it would be a remand for the judge to explain why he denied the expungement, right? I mean, that just seems to be in line with this case, because he explains to us why he granted the ceiling, but he doesn't explain to us why he denied the expungement.
I respectfully think by its order of statute, the language of the ceiling and expungement statute under D2, the trial court doesn't, I think, get the opportunity now to re-explain that. When it's already found the factors in the defendant's favor, D2 says that, or the applicant's favor, D2 says shall order the application expunged if upon an application for expungement. So there's some tension there. If you're giving the trial court an opportunity to re-explain itself, it's getting to kind of circumvent that mandate, the
Well, I mean,
statutory
but he
mandate.
denied the expungement, so there's got to be a reason. He
Or-
just didn't tell us, and maybe it's an abuse of discretion.
So to that
Maybe
point.
his reason is,
Yeah,
I
to
don't
the-
know.
To the point of the abuse of discretion standard, an abuse of discretion can be found when the trial court's decision is inconsistent with the record before it, which I think is what I'm hanging my hat on in this case. The record and the trial court's decision clearly support all of the statutory factors in NS's favor. So there's no reason to give the trial court an opportunity to review the expungement again because the abuser's discretion in denying it in the first instance. The record supports expungement.
Yeah, so the statute says if these, 9 factors are met, then the expungement shall be granted.
Yes.
And the trial court in this case found those 9 factors, right?
Mm-hmm.
And didn't give any explanation for a denial.
Correct.
So your argument is the factors have been satisfied, there's no explanation for a denial, it's mandated that expungement be granted.
Yes, or it's an abuse of discretion because the record supports the expungement. However we come at it, it's mandated by the statute or an abuse of discretion based on the record. If there are no further questions, I will submit on my briefs and ask that this court reverse and order that the expungement be granted. Thank you.
Thank you. Thank you so much. Thank you both for your arguments this morning. We'll take the matter into submission and issue a timely decision. I hope you have a wonderful week, and maybe you'll leave singing in the rain. I don't know. It just seems interesting that everybody's talking about the rain, everybody. Again, we're very dehydrated in Cincinnati right now. Have a great one. Take care.
Thank you.
That concludes the proceedings.